I appreciate everybody coming out today, and it is obviously exciting given the fact that on May 16th, Title III will go live, and we will have the beginnings of the industry that many of us in this room have worked so hard to make happen. But before I go into Title III, I want to mention that my name is Doug Ellenoff. For those of you who don't know me, I'm a partner in a New York-based law firm, Ellenoff, Grossman, and Schole. We're 70 lawyers, 10 of which practice crowdfunding law, Title II, III, and IV, on a regular basis. I'm joined here by one of my colleagues, Georgia Quinn, who, besides being the co-founder of iDisclose, which I'll talk about in a minute, is also a lawyer at the firm. We have worked with the SEC and FINRA tirelessly to bring Title III to life, as well as we've worked with federal, state, and international regulators to make it all happen. I want to thank Sydney in particular, who's been a consistent supporter of this industry. He has had this event now for 4 years. CrowdFund Beat is one of the go-to online media publications to learn about all things crowdfunding, and it is warmth and generosity that brings me back every year. So Sydney, a heartfelt thank you. Now time for my shameless plug for Georgia and the iDisclose application that we're here hawking. It is a TurboTax tool-like tool for entrepreneurs to comply with Form C compliance in Title III. It also has a PPM tool for Title II, and Georgia would love to give you a demonstration of that tool when you have time today. I also want to express gratitude to all of the pioneers in the crowdfunding industry that are here and worked with me, my firm, and all the other participants in the industry. And I'm actually going to list them because I don't think they get nearly enough recognition. They have been committed and involved for 4 years, consistently supporting the industry. And that's Richard Swart, who you'll hear from shortly, DJ Paul, Steve Sinelli, Mark Roderick, Sam Guzik, Georgia, Jonathan Fruitkin, whose book you should read, Gene Massey, and Oscar Joffrey. They're all here. They're all willing to talk to you about all things crowdfunding, and I would encourage you to reach out to them to educate yourself. They're a wealth of information. And of course, now my notes have gone away. So I'm not going to wing it. Oh, that's nice. Really nice. Okay. So now I'm going to get into the details. For all the new attendees here today, please recognize that years of foundational effort have brought us to this point. So while it may be new to you, it is no longer about if, but how well and how much and how pervasive the Jobs Act crowdfunding will be. Excuse me. In just a few years, and now I'm going to give you some macro numbers, and Richard will drill down shortly. The SEC will put out numbers that there's the private placement market is $1.4 trillion a year, and that crowdfunding, broadly speaking, is $23 billion. That includes marketplace lending. It includes offline crowdfunding. But the point I'm going to make is about online crowdfunding, and I'm going to back out of those numbers, the lending numbers in particular, but leave in real estate. Just at a quick review of the major sites that I did last night, I'd say there are 15 to 20 crowdfunding portals, both real estate and venture, that have really demonstrated the economic viability of the funding platform model. You have about, like I said, 15 to 20 that are doing anywhere from $50 million a year to $200 million a year of activity. And those include Our Crowd, Realty Mogul, AngelList, and they're funding every single day entrepreneurs, whether real estate professionals or just venture folks, in activity that might not have been financeable previously. And so while that may not seem like a lot to more established capital market participants, that is the beginnings of an industry in less than 2 years that the narrative a couple of years ago was hostile towards, and particularly in this community where they were not pro-crowdfunding at all. And then you add to that some regulatory sensitivity as well. And it's actually remarkable how quickly and how far this industry has come in such a limited amount of time. I'm going to put it into a bit of perspective for you. My law firm has been innovative in several alternative finance programs over the last 25 years. They come with acronyms like PIPES and SPACs. And those two programs in particular, which are mainstream financial services programs today, they weren't always. Now, when we started doing SPACs, which is a registered blind pool IPO, in 1993, when that program started, those financings were $10 to $25 million, and they were few and far between. It took a decade before they kind of scaled up and started being $200 million financings. And there was still concern whether or not it was reputable practice. And now, another 10 years later, so 20 years into the cycle, we do SPACs on a regular basis for the most high-end private equity folks in the world with the largest underwriters in the world, and it goes down without a hitch anymore. So things take time. The PIPES market probably took half that amount of time, and that's a private placement into a public company. And we probably did 65 of those last year. And again, it is normal activity, even though when it was first initiated by people who were quite creative, it was not embraced by Wall Street. So crowdfunding, for those of us who've been involved, the people that I mentioned previously, we listened to a narrative that was distrustful and concerned about crowdfunding, and it's actually turned out to be anything but that. The most prevalent concern that was raised in 2012, not surprisingly, was whether or not crowdfunding would be ripe with fraud. And it was something that we heard constantly and consistently. And the SEC just put out a report from their Division of Economic Risk Analysis last week and said, in the context of the numbers that I've already presented you, there is minimal, if any, statistical fraud that they have observed. I'm not saying fraud doesn't exist. I'm not saying that there won't be fraud, and I'm going to give you some insight as to one fraud in a moment. But at the same time, it was never a good reason to frustrate or inhibit this industry from growing, so I think there was a lot of false narrative, again, that slowed the process, Title III in particular, because that's dealing with the most sensitive class of investors, the unaccredited investors. Title II has now been in practice for 18 months, and the online business has probably done better than $1 billion, and hundreds of companies have raised money that might not have done so previously, but certainly they've done it in a more efficient and intelligent way and transparent way through these online mechanisms called funding platforms. From a regulatory point of view, you can also track what activity has taken place between the platform, the entrepreneur, and the investor, and if the platform is designed properly, the experience overall is better, it's more efficient, and if there's a problem, you can go back and figure out what happened and whether or not there was any wrongdoing, but there really hasn't been, and that's comforting, and that's in the Title II space, which is the longest record so far, as opposed to Title III, which again is just starting in May. So that's the good news. Just quickly for those in the audience who may not, is there a show of hands? Am I speaking shorthand Title II, III, and IV to people who don't know the difference of those? Okay, I'll do that quickly for you. My apologies. Title II is the ability of an entrepreneur to do a general solicitation to investors through any mainstream media or email campaign that they would like. It kind of makes private placements a misnomer because you can do a general solicitation the way a public offering could be done. There are other rules that are associated with it, which I won't go into those details, maybe some people will later, but you can raise an unlimited sum of money from investors as long as they're actually accredited investors and you take reasonable steps to verify that they're accredited. U.S. investors. That doesn't mean it applies to international markets, because if you do a general solicitation into Canada or other countries, you're probably violating their rules. That's the oldest. That's 18 months old at this point. Title IV, which went effective in June of last year, is what's called Reg A Plus, which is an evolutionary statute to what was old Reg A that limited the amount of money to $5 million. Reg A Plus allows you to raise up to $50 million, but you have to file what's tantamount to a registration statement with the SEC that gets commented and reviewed like any IPO. You can test the waters before you do that, which is what makes the Reg A program so interesting and what has given it a lot of early success so far. My hat's off to Ron Miller, who's here today from Start Engine, the Elio Motors team. They closed their first Reg A Plus offering of slightly less than $20 million. And there are another 60 to 70 Reg A Plus filings on file with the SEC as we speak. So that industry is off to a good start. We'll have to see what the actual close rate is between the indications of interest in a Reg A Plus offering during their Test the Waters campaign and the actual number of investors who actually invest in that deal, in those deals, to see whether or not people, when they're soft-circled, actually put up the money 60 days later or whatever it ends up taking. That's Title IV. Title III, which is something I've spent a tremendous amount of time and believe very strongly in it, is up to $1 million of financing, but it must be undertaken through a crowdfunding platform that's approved by the SEC and FINRA to conduct such activity. Any American, like in Title IV, which allows accredited and unaccredited investors to participate. Title III allows the same, and you're limited as to how much money you can put in as an individual in one particular deal or in an aggregate in a 12-month period. And that business will get off to start on May 16th. So that's Title II, III, and IV. All of these programs are new, and you're hopefully going to learn from a lot of the professionals today and see why what you thought about crowdfunding previously may actually in reality be different than what is written about in the press. It is being undertaken by responsible individuals who don't necessarily, but many of them do, have securities backgrounds. This is the sale of securities. Make no mistake about it. It is a highly regulated industry. It is not for people who think they can make a fast dollar. I think any entrepreneur in this room who's been involved in the industry will tell you these things take time, they take effort, and there's a lot of regulatory implications to the things that are being conducted, and you don't want to hear from a state or federal regulator that you might have done something that could get you into trouble. That was all off the top of my head without looking at my notes. So Title III. So Title III, there is concern that there's been a narrative that we haven't done that much business in the short time that crowdfunding's been around. I think that that is undersells what we've accomplished. I think to do $1 billion from a standing start of activity online is responsible. There haven't been the problems that people assumed would take place. And that is the way all of the people who are involved in the crowdfunding platforms and the entrepreneurs have conducted themselves. We've seen very little real cause for concern. Title III will be no different. So what's the Title III opportunity today versus in 2012 when the enthusiasm was so high after the president signed it into law? And the answer is a lot of the crowdfunding platforms that were going to do Title III platforms will not do crowdfunding platforms under Title III over the next 12 months necessarily, because you have to close a good number of financing transactions on your platform in order to have an economically viable platform. So a T3 Title III platform, my estimate, and it varies depending on where you are, how many people you staff it with, it's got to do, I don't know, $25 million of closed transactions a year, maybe 50, maybe 100. As I said, there are only 50 to 20 platforms that have done that size amount of business to date using Title II, which allows unlimited fundraising. So if Title III caps you out at $1 million, you're going to do 50 transactions in a year, assuming that you max out at $1 million? I don't think so. So I think what we're seeing in our practice, and we have many platforms and entrepreneurs that are considering filing with FINRA to become a Title III platform, that most of the activity so far has been from existing participants in the industry. A Kickstarter, not that they're going into Title III, but they want to broaden their service offering from pre-order campaigns to also doing securities transactions, so they could add a T3 platform to their activity, because they can raise a lot of money in a pre-order campaign, keep the lights on, and then also add a little T3 activity to really engage the crowd. Title II platforms will do the same thing for the same reason. I think you'll see some of that with Reg A Plus as well. You have to be very mindful of the rules of integration and the concerns that the Securities and Exchange Commission and states have about conducting multiple offerings at the same time. As I said, you have wonderful securities professionals here. You can talk to them. Mark Roderick's back there. Sam Guzik will be here, I believe, as well later. I don't know if Kendall's going to be here, but there are a lot. Excuse me? Oh, Mark, okay. So there are other securities lawyers here as well that you can speak to about those issues. That doesn't undermine the fact how good Title III is. Those are the people who it's going to make the most sense to do it initially. As the opportunity broadens and the people see, or entrepreneurs see, that accessing money from unaccredited investors isn't as spooky as people make it out to be. Ron's experience with Elio, I bet Ron would say that having the crowd in the capital stack is a good thing. It shows the passion of those individuals to the product in the Elio Motors deal that is being offered. So over time, I think you'll see more standalone Title III platforms emerge. I don't think you'll see it initially. I've seen different estimates as to the number of portals that are going to apply to become T3 portals with FINRA in the first round. We're working on a bunch. I hear about others, but is it going to be 100? I don't think it's going to be close to being 100. I think it'll be below 50. But that's good. I think it means that the responsible people are going to start the pathway forward. And if they do what they're supposed to do in a responsible manner, the way we all hope that they will, the way the T2 and T4 operators have, then the Title III world will be a success. But it's not going to happen in 6 months or a year or 2 years. Like my other programs, you have to be patient, you have to do things responsibly, and you got to stay out of harm's way. So that's the background of why we're here. There's some wonderful speakers today. I hope everybody mingles. I think there's a wealth of information for those who don't know the industry to tap into. Don't be shy. By all means, you can also talk to me. Bless you. And Sydney, thank you for the opportunity to speak today. And again, go visit Georgia Quinn at iDisclose. Thank you.